Richard I. Fine has spent the last 4 months in Los Angeles County Central Men's Jail fighting court corruption in the California state courts, and as a result is being held in contempt of court. In his struggle, he has been purposely hindered at every step.
I filed the writ of habeas corpus on March 19th. I was incarcerated on March 4th, and the reason for the delay between March 4th and March 19th was that I did not have any in pro per status and I did not have any pencils or paper. So I actually had to dictate the writ of habeas corpus to friends of mine in order to get it filed.
A writ of habeas corpus is a demand that a prisoner be brought before the court, together with proof of authority, requiring the court to determine whether that custodian has lawful authority to hold that person. If not, the person is to be released from custody. The U.S. Magistrate Judge is Carla Worley. According to Mr. Fine, in handling his case, she has violated a bunch of laws, stalling to keep him locked up.
Then what happened is that the magistrate judge immediately started breaking the law. Under the law, and the law is 28 United States Code Section 2243, upon receiving the writ, the petition for the writ, she had to either issue the writ, and the exact words are forthwith, or she had to issue an order to show cause to the respondent, who was the sheriff, forthwith. Instead of doing that, she waited approximately 19 days until the 7th of April to issue her order to show cause to the sheriff to respond to the petition. So that was the first point where she violated the law. She should have really issued her order to show cause probably by around March 20th or March 21st.
In his petition for the writ of habeas corpus, Mr. Fine identified 7 grounds articulating why his confinement was unjust and illegal. Magistrate Judge Worley, Superior Court Judge David Yaffe, and L.A. Sheriff Baca were ordered by the court to respond to Mr. Fine's grounds in his petition. They apparently didn't read or simply ignored his issues.
They did not respond or answer to any of the 7 grounds in the petition. They did not dispute or respond or contest any of the facts set out in the petition, and they did not dispute or contest any of the claims set out in the petition. I had filed on April 9th an ex parte application to be released pending the decision on the petition, and none of them had come up with any reasons that ex parte application should not be granted.
So why is he still in jail? His petition required them to document the reasons for his incarceration. Here in America, the courts and the jails must clearly spell out why someone is forcibly confined, and yet no one in authority responded to the issues in his petition. So technically speaking, are they opposing his release?
The answer to that is no, because none of them opposed any of the grounds or the claims or the facts in the petition.
Well, how could this happen? It appears that none of them are having any regard for the statutes or the rules.
Then you're absolutely correct. All of them, at this point in time, the sheriff, the LA Superior Court, the sheriff violated the law by not giving reasons for my being in here, and also didn't respond to the petition at all. And the LA Superior Court and Judge Yaffe, in a sense, violated the law by not directly responding to the petition, and also did not answer any of the grounds, the facts, or the claims, and did not oppose anything in the petition. So right now, it turns out that the sheriff, the LA Superior Court, and Judge Yaffe have basically thrown in the towel. They're not opposing anything.
According to Mr. Fine, by not opposing anything in his petition, his arguments stand. That means they have no grounds to continue holding him. That's according to the law.
And the magistrate judge has gone through and has violated the law, the 28 U.S.C. Section 2243 on all the counts that I have mentioned. So I should have been out of here as early as probably April 12th.
This phone call was recorded on June 30th, 10 weeks later, and since a recent Supreme Court ruling, Mr. Fine has even more ammunition to use in his defense.
But it gets even worse, because on June 8th, the United States Supreme Court came down with the decision of Caperton versus Massey, the Massey Coal Company. And that decision basically holds that if you have an appearance of impropriety, the judge who is sitting on the case has to recuse themselves, which mandates that Judge Jaffe should have recused himself both in the underlying case and in the contempt proceeding. And the magistrate judge didn't even take that case into consideration when she came out with her ruling.
I had to question how U.S. Magistrate Judge Worley could justify her actions. In light of the fact there was no opposition, how can she come up with a recommendation that you should remain in jail without any opposition from the other parties?
Well, I don't know what's in another person's head, but having read her document, it is literally impossible for her to come up with that recommendation. I mean, that's number one, based upon the fact that there's no opposition. But it gets even worse, because in reading her document, I came to realize that she had not even read the entire petition.
It seems unbelievable that a magistrate judge will make a recommendation to continue the incarceration of someone while failing to read and respond to a petition from the inmate who is an accomplished prominent attorney. We asked Mr. Fine where he got this idea.
The magistrate judge said that there was no criminal charge in the contempt proceeding. And that indicated that what happened is that the magistrate judge never read the order to show cause, which was the basis of the contempt proceeding, because in the order to show cause, it showed that I was criminally charged under Business and Professions Code Section 6126 for practicing law and holding myself out to practice law. And that was a criminal charge with a sentence of up to 1 year in jail. She claimed that that charge didn't exist, which indicates that she had not even read the order to show cause. So I knew that she hadn't read either the transcript of January 22nd, 2009, nor had she read the minute order of January 22nd, 2009, and nor had she read the papers that I filed in the California Court of Appeal or the California Supreme Court, and nor had she read the exhibits to the petition.
It is amazing that Mr. Fine is taking on not only the judges of the Los Angeles Superior Court, but also the judges of the United States District Court. It is inconceivable that he's doing so without an attorney representing him while incarcerated in the county jail. Well, now, for our viewers' sake again, I'd like you to explain why is it you are representing yourself?
Well, I'm representing myself because of the fact that we could not find any lawyer that has experience in this area who has the courage to represent me in this case. And the reason for that is that this case has such importance and is so big that every lawyer is basically afraid to take it on. Because the effect of this case is that in winning this particular writ of habeas corpus, you have effectively gone through and removed about 1,600 Superior Court judges in California. And you've definitely removed all of the 430 Superior Court judges here in LA County. But the interesting thing is that these judges have already thrown in the towel by not having contested the petition.
Mr. Fine is adamant that LA Superior Court Judge Jaffe, Magistrate Judge Carla Worley, and Los Angeles Sheriff Leroy Baca are illegally keeping him in confinement.
Any way that you look at this petition for writ of habeas corpus. I should have been out of here a long time ago.
He's still fighting hard. In a phone call just today, Mr. Fine asked me to read this to our viewing audience. Quote, both Magistrate Judge Carla Worley and District Judge John Walters have not disclosed that they were criminal defense attorneys, and as such they have a personal interest in the outcome of this case, and therefore were bound to recuse themselves from this case, and their failure to do so has denied my due process of rights. Both Magistrate Judge Carla Worley and District Judge John Walters have not disclosed that they were criminal defense attorneys, and as such they have a personal interest in the outcome of this case, and therefore were bound to recuse themselves from this case, and their failure to do so has denied my due process rights. Today we are mailing to the Ninth Circuit a supplement to the writ of mandate asking for an immediate release. The usual expectation is that the writ would be granted because this case is a case where there's no opposition to the writ of habeas corpus. The district courts have violated the federal law, and now we have a situation where neither the magistrate judge or the district court judge should have presided over the case. So we either have the writ of mandate or we appeal, and we will win the case on appeal. He says that in his opinion, they are afraid to do the right thing because they knew that they would be sued for malpractice by their criminal law clients who lost. The people who lost just now would be learning of these circumstances and would not have had an opportunity to raise this issue earlier. We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1. Do you think that this story is important enough to be covered by the mainstream media? Yes or no? Number 2, do you think it's appropriate for a 70-year-old attorney to be incarcerated in solitary confinement for an indefinite sentence for challenging the judges? Yes or no? And number 3, do you think Magistrate Judge Carla Worley and District Court Judge Walters are deliberately violating the statutes and rules to protect themselves against malpractice, as Mr. Fine suggests? Yes or no? Be sure to leave your comments below. Thank you.